Unanimous.
Thank you for the list.
Mr. Osakwe? Good morning.
Morning. May it please the Court, Madam Chief Justice, Associate Justices. My name is Gregory Osakwe, and I'm the pro se petitioner in this case. I applied to the Board of Bar Examiners to be permitted to sit for the Massachusetts Bar Examination, and they denied my application and are requiring me to first obtain a JD before being allowed to sit for the bar examination. Your Honors, the two main issues before this Court are whether under the SJC rules and this Court's decision in WJ, I don't know if I'm pronouncing that properly, whether the petitioner is eligible to sit for the bar examination, and secondly, whether the Board of Bar Examiners has sufficiently applied those rules in assessing the petitioner's educational qualifications. The petitioner holds a law degree from a common law faculty in a foreign country whose jurisprudence rests upon the English common law tradition. This assertion is not currently challenged by the Board of Bar Examiners. What the Board is challenging in their brief is that under the SJC rule, Section 7, the petitioner is not sufficiently educated to be tested by the Massachusetts Board of Bar Examiners.
Have you submitted a transcript of the courses that you took in that law school?
Yes, Your Honor. The transcript is in the appendix, and it's at page appendix 68 to 72.
And did that give a description of the courses and not just the name of the course, but what the courses actually were dealing with, the subject matter of each course?
Yes, Your Honor. I submitted the transcript and the course descriptions. And the course descriptions are from page 71 to 72. And that list explains the courses and what the courses detailed. Furthermore, in my brief, Your Honor, at page 13 and 14, I referred to certain courses and compared them to course descriptions in Yale Law School and NYU to show the similarities in the courses, in the course descriptions in the university I attended, and the course descriptions being offered, in Yale and NYU.
Counsel, Mr. Osakwe, can I ask you this? I read through your appendix, and maybe you can just give me the bigger picture here. In Nigeria, where you studied both undergraduate and postgraduate law school, right?
Yes, Your Honor.
Okay. How is that structured? Your entire undergraduate education was law-based or law-directed? Am I misunderstanding?
Law-based. You're correct in that, Your Honor.
And
That is the British and common law country system.
Yes.
That you go from graduation of what we would call high school directly into what is called an LLB, a legal training, correct?
Correct, Your Honor.
Is that a 5-year program?
It's a 4-year program.
Okay.
And then in addition to that, you went on to advanced study. How is that? What is that called?
Well, you do the LLB,
Yep.
and on obtaining the LLB, you then go to the law school, which is a universal law school, where all the LLB graduates attend.
Now, do you have to take an exam to get into the law school, or is it just an automatic progression?
If your university is accredited,
Okay, you get in.
then you get in automatically.
Okay.
But then you are then tested, you then sit for the bar exam, because having an LLB doesn't mean that you are
Yeah,
admitted
it's
to
a
the bar.
it is, as it were, a further professional qualification.
Yes, Your Honor.
And is that a 2-year program?
It is currently, at the time I attended it, it was a 1-year program.
All right. And then after you finished that program, you then qualified to take the bar exam in Nigeria,
Yes, Your Honor,
which you did.
which I did.
And so you became a lawyer in Nigeria.
Yes.
And then you went to Trinidad?
I went to Trinidad. Trinidad evaluated my qualifications, and I underwent what was called a 6-month orientation program. I was not required to sit for the bar exam for the bar. They reciprocated. So after 6 months, I was admitted to the bar.
All right.
Is it the case that the highest court of final appeal from Trinidad is the Privy Council and the Law Lords?
Yes, it's still the Privy Council.
So you were practicing in what is obviously a common law jurisdiction in Trinidad as well?
Yes, Your Honor.
And how long did you practice in Trinidad?
I practiced in Trinidad from 1996 until 2000, 4 years.
Okay. And then you came to your course study in Connecticut?
I came here and then I enrolled in University of Connecticut and did an LLM. And while I was doing the LLM program, I was recruited and I started working in a law firm as a law clerk.
All right. And so during the period of time you were getting your LLM, you were working as a law clerk in one of the law firms down there?
Yes, Your Honor.
And when you completed the LLM, was that when you applied to take the New York bar?
No, I felt that I did not have sufficient experience. So I waited a year, and then I sat for it in 2002. After I passed it, what I didn't know was that I had to do professional responsibility to be admitted, to be certified. So even though I had passed the bar in 2002, I had to sit for professional responsibility in August. And the next admission were in February 2003.
Okay.
So that's why I was admitted in 2003.
And so the year between finishing the LLM at Connecticut and applying to sit for the New York bar, did you work in Connecticut in a law firm, or what?
Yes, Your Honor. I worked entirely in the law firm. I resigned from the law firm in 2004.
Okay.
Mr. Osakwe, you have applied to sit for the Massachusetts bar, am I correct?
Yes, Your Honor.
Are you currently a resident of Massachusetts? Where's your primary residence?
My primary residence is in Connecticut. That's a very good question, because at the time I applied to sit for the Massachusetts bar, I was
Intending to
well, we were looking for a house in Long Meadow. My wife had just started working in Springfield. So I wanted to expand my practice to Massachusetts. What I discovered was that in order for me to practice in the federal district courts in Massachusetts, I had to be a member of the Massachusetts bar, even though that's not required for the First Circuit, because I was just concentrating. Well, I am concentrating my practice in immigration law and immigration, federal-related matters to do with immigration. So that is when I applied to sit for the bar exam.
I understand.
So, what the respondents and what the board is saying, or the current argument, Your Honors, is that I am not familiar with the courses listed in Section 7 of the of the SJC rules. My understanding of that section is that the 18 courses, 18 subjects, are the subjects that an applicant for the bar exam is tested on. I don't think they're suggesting that every applicant or every JD holder or LLB holder in law school in the United States, in any ABA-approved law school, did these 18 courses. The 18 courses, and
Well, I'll be a witness on your behalf with respect to several of these courses.
because everybody, or most people, do the bar review courses, and the bar review encompasses 18 courses. When I sat for the New York bar exam, 15 out of these courses were courses I was tested on for the New York bar exam. The only two courses listed that I was not tested on, or I'm not familiar with, which basically is the Massachusetts Rules of Civil Procedure and Unfair and Deceptive Practices.
Now, it's a bit of a pity that you took the New York bar, because you may know that the New York bar has never adopted, excuse me, the federal rules of civil procedure. So it's a little, it's a little odd, but Massachusetts does have the Massachusetts rules of civil procedure, which are largely based on the federal rules of civil procedure.
Yes, Your Honor, but I did take that course in University of Connecticut.
Oh, I understand that.
And I take it your practice now, as you were describing, is principally a federal immigration practice in Connecticut
Yes, Your Honor,
and New York?
and New York.
And you were admitted to the bar, the federal district court bar in Connecticut.
Yes, Your Honor.
And to get admitted into that bar, do you simply need to demonstrate that you are a member of a bar somewhere, or New York bar qualified you, or how did you get qualified?
Yes. Well, I believe that because New York and Connecticut are all under the Second Circuit,
Okay.
so being a member of the New York bar
Qualified you.
qualified me.
Thank you, Mr. Osakwe. Mr. Muldoon?
May it please the Court, Robert Muldoon for the Board of Bar Examiners. My colleague Katie Koski is with me. I have 3 brief points to make, if it please the Court. First, the reason for the educational standards which the Court has through the Board of Bar Examiners established. Secondly, the burden on those applicants who are foreign educated with respect to law school. And thirdly, whether or not Mr. Osakwe has met the burden that's imposed. This is not a conventional adversary proceeding, as Your Honors have pointed out in various proceedings of this type. This is really in the nature of a review of the discretionary action of the agency which the Court uses to determine qualifications.
Mr. Muldoon,
Yes.
Could I ask you to help me with the difference between Mr. Osakwe's request to sit for the bar and the last time I think we addressed this, which was why GIA.
Yes.
In that case, we said if there were greater similarities between the People's Republic of China and our law, if the former were based on the English common law system, I think it cannot be disputed that the Nigerian legal system is not only based on the English common law system, but probably has a more robust connection to the English common law system.
I think, if Your Honor, please, what Nigeria says about that can be found extensively at pages 26 to, I believe it's 38 in the appendix. In Nigeria, the Federal Republic of Nigeria, as I understand it, the admitting body is national, and it is the Council of Legal Education. The Council of Legal Education recites the creation of the Nigerian Law School as a separate national operation, separate from the 30 or so law schools which grant LLB degrees at universities in Nigeria. The rationale for the creation of the Nigerian Law School is set out in detail in these proceedings and these statements from the Council of Legal Education. And it's fair to say that with respect to the relationship even of English common law to the operation of Nigerian law, the Council of Legal Education, and I'll quote a few of the passages to you, points out that even education at the Inns of Court in the United Kingdom is not sufficient in light of their view of what the educational requirements for Nigerian admission itself would
but that's
require.
That's no different. But the fact of the matter is we have given, have we not, or suggested that a civil law jurisdiction. So if this were Senegal, it would be a very different. It strikes me as a very different situation. Because that system of law, I mean, maybe if you were going from Senegal to be admitted to Louisiana, but here we've suggested that there is something. I mean, maybe the common law's disappeared in Massachusetts, too.
The description of a legal system as based on common law principles is a description which is offered as a bar examiner. I know this because we get hundreds of applications a year from quite a number of I believe, several dozen jurisdictions over the last 5-7 years, and 125 law schools. And you, I think, would be surprised that the number of countries which find a basis in common law for their practice. The idea, the declaration that we are a common law jurisdiction means different things to different people.
No, I understand that, but if you...
And I beg your pardon.
Go ahead.
That the question of what constitutes a legal education that meets the standard, and the standards have, in this Commonwealth, become, over the last 125 years, more and more rigorous. And the application of the equivalency rule, we start with the court's rule, not the board's rule, the court's rule in 301, section 3.4, namely that the first step we have to make is find that there is an education equivalent to that provided by ABA law schools. There are many law schools in this country which are based on common law principles in jurisdictions that are common law that are not accredited by the
No, I
American Bar
understand
Association.
that, but I mean, essentially, in any event, because I want to go on to some of the other aspects of YGR, but it strikes me that we can say, you know, you have to have a law degree from an ABA accredited university. We haven't done that. We haven't done that. So if you say they have to be the equivalent of, I could certainly understand the People's Republic of China, not because they don't have great lawyers there, but because it's a very, very different system. Very different system.
I may have misunderstood, Your Honor, but I believe that in 3.4 is that the test for the principal legal education of an applicant educated in a foreign law school is that it is equivalent to that provided in law schools approved by the ABA. The Court hasn't changed that rule. The Court has provided guidelines in WAGIA and in rules approved by the Court for the exercise of discretion by the Board, but that's still there. And the test of whether an applicant's education in a common law country or any other country meets that standard imposed by the Court invites questions, as Judge Graney noted in his order dismissing the previous application, I believe, for mandamus that was started before this appeal came, that it's not simply saying that it's common law. It's not simply listing things. It's the nature and quality of the education. Mr. Osakwe's education in Nigeria commenced in 1984, I believe, and concluded in 1989. There is nothing in the record other than the bare identification of courses that he took that remotely approaches the standard that we apply to everyone else from ABA-approved law schools, namely the nature and quality of that education. The ABA process is one which has been applied here and throughout the country in order to increasingly professionalize by way of rigid educational standards the education of those who would get a general license to practice law. Starting from Rule 3.4, Section 3.4, we have to inquire, and the applicant has the burden to provide information as to the nature and quality of that education. And that means a far more searching amount of information as to what the education was at the time he had it, what the quality of the professors were, whether or not the law school met anything remotely like the standards for library and other resources. And that is apart from the question, as you'll see, as I pointed out, the Nigerian Law School Council Legal Education Standards, is that a great part of education in Nigeria comprises what the council calls the customary law of Nigeria, which, as they say later, provides a disorientation for those who are educated in the United Kingdom.
Of course I understand that, because you've now got a licensing procedure, but as far as I can, I don't know whether we have ever asked a foreign graduate to tell us how many library books, or, maybe we have. I didn't understand that we were using that kind of inquiry, but the list of courses that he took as part of his LLB, the LLB is an absolutely standard law degree, so you don't only look at the licensing one. there may be overlapping law. There are, for example, I'm quite sure that if you want to practice in New Orleans, you have to know a lot about civil law, for example. But it struck me that, if you recognize that Nigeria, in fact, is based on a common law tradition, when you have things like the law of contract, the law of evidence, the law of so on and so forth, you're in the same tradition, not a completely different one.
You're in the same area of nomenclature. It is not enough, if Your Honor, please, to say that the nomenclature provides the warranty of quality education, which is the reason why the standards for education for lawyers to be admitted to have a general license in Massachusetts has gone from reading law up until 1897 to then an undergraduate degree, then to 2 years from college, and then by the 30s, a full undergraduate degree plus the 3-year program. Then in the middle 30s, the development of standards for that education as developed by the ABA.
Mr. Muldoon, what do we? I understand if this gentleman were simply had finished his education in Nigeria and were coming here and wanted to sit for the bar. I mean, all of these questions would strike me as being perfectly appropriate. But you have someone who has practiced law in Nigeria or admitted to the bar in Nigeria, moves to Trinidad where he takes additional courses, is certified and licensed to practiced there for 4 years, another clearly common law country, comes to the United States, gets an LLM at the University of Connecticut, fine school, is qualified to take the New York bar by the New York comparable board. I understand their standards are a little different. I've looked at them. Passes that, passes the MPRE, is practicing law in the federal courts in Connecticut for the last whatever many years. Does not any of that count?
It counts.
Or do we just ignore all of that?
It counts as factors to be considered.
But that's why I went to Wade G. I mean, one of the problems we had in Wade G, YG, was that he had audited a lot of courses, and that all of the LLM courses that he had taken consisted entirely of international business law classes. I mean, it just seems to me we have two very different candidates here.
Your Honor, please, I think the candidates are alike in that there is no weight of evidence, of any evidence, as to the nature and quality, and I'm using Justice Graney's words, the nature and quality of the education. With respect to the admission in other states and respect to practice, the fact is that, as is shown as my brother has already said, his practice is restricted and has been to federal immigration practice. The application here is for a general practice of law license.
Yeah, but his training wasn't in immigration law. I mean, I know lots of Boston attorneys whose practice is limited to immigration law. But if he had come and said, I took these immigration courses, these immigration courses, these immigration courses, that's one thing. I mean, essentially, this is a barrier to his practicing in the federal courts of Massachusetts, because the Massachusetts District Court has said, we want you admitted in Massachusetts.
If the court, as some courts are considering, and as the ABA section on legal admission, education and admission to the bar, if there were licenses for specific specializations, that would present a completely different question.
No,
the difficulty is that there is no way that the court can grant a license limited to a practice. And
when the board has admitted people from Canada, which it has, as I understand, has it asked for a statement from the applicant that you tell me how many books there are in the library, what the qualifications are?
If Your Honor, please, Your Honor will recall that the court has allowed graduates of the common law faculties of those Canadian universities that belong to the Law School Admissions Council to sit for the examination. The court's rule was that on the basis.
I'm talking about people who haven't sat for, who coming in this way. I mean, who've practiced in Canada.
I'm not sure I understand the question.
in a non-automatic, because you're not part of the American, then you're part of an American accredited law school, correct?
Yes,
So then you're not sitting as a non-accredited law school.
that's correct.
And if you are sitting in a non-accredited law school, in other words, it's
From Canada?
yeah.
You can't take the exam without going through the examination of the nature and quality of the fundamental legal education one has, plus the other aspects, the acquisition of an LLM. The ABA has cautioned bar examiners and admitting authorities and courts for some time that LLM programs are not rated by the ABA and are not useful substitutes for the protections, the consumer protection that the accreditation process seeks to ensure. And
Well,
that's
they may
the
be
fundamental.
useful if in fact most of the LLM program is, American civil procedure, American criminal procedure, torts, United States legal institutions, which include a contract law, including the UCC. That may be a relevant inquiry, correct?
Except that to the degree that the court depends on the evaluation and accreditation competency of the American Bar Association, they have told us that they don't believe that to be the case from their standpoint.
I understand.
So I'm sorry, you're suggesting these courses are not the courses that law students would take these are special courses at University of Connecticut Law School?
They constitute a few of the courses that law students in accredited schools would take over a 3-year period.
And
I know.
I hate to mention the small, not the University of Connecticut, the small other law school in Connecticut that requires, the last time I looked, 1 semester of required courses.
Yes? I don't know if that's, I know other law schools that have higher requirements.
I know, that one was such a, we invent them all the time, and maybe
Right.
that was a big mistake.
Right.
And regarding the fact that he's passed the New York bar, you say that's just something to think about, but it has no persuasive.
It has an aspect.
I mean, that's a difficult bar to pass, isn't it?
Well, that depends. The quantum of failure depends on the freedom and liberality of the Court of Appeals of New York to permit quite a large number of people who wouldn't qualify under any consideration here to sit. So there's a low passing rate.
How many years does the holder of somebody who's admitted to New York get waived into Massachusetts? How many years?
If there is no fewer than 5 years from the out-of-state admission, plus a finding of the nature and quality of practice or law teaching from the time of the admission. Someone who has been admitted, for example, in New York in 2000 and then does various other things, and in 2004 comes back, they qualify on being admitted, but then the question is that the board has to examine is whether or not the nature and quality of the practice since that time would warrant us to say that this person has the attainments, character, and fitness to practice law.
Thank you, Mr. Mulder.
Thank you very much, Your Honor.
All right. Hear ye, hear ye, hear ye.